We have had a fitting start to the opening of this new law year by giving thanks to God for what He has done and continues to do for us as we participate in the administration of justice in this country. Dominica over the years has faced the challenge and endured the limitations that is a natural consequence of having only one resident judge on island. Over the last few years, headquarters in St. Lucia, realizing the very real delay that this has caused to a timely disposal of matters, made arrangements to have judges sent to us on temporary assignment to deal with civil matters. While we were grateful for this, it was insufficient to address and eliminate the backlog of matters in the court. If it takes 4 to 5 years before a case can be heard, then we risk persons losing confidence in the system. In respect of caveat matters, we had situations where cases were waiting to be heard for over 10 years, and by the time these matters were heard, key witnesses had died. We are grateful to you, Chief Justice, for arranging for the assignment of Justice Albert Matthew to deal primarily with hearing and disposing of the caveat cases which were languishing in the system. We are extremely grateful, and I wish to express the thanks of the government to Justice Matthew for so readily agreeing to come out of his retirement to assist us. His sacrifice has truly been appreciated and has had a great impact. I am informed that out of the 75 caveat cases that were placed before Justice Matthew for hearing, 64 were disposed of, 11 were not dealt with because of non-compliance with directions, and 15 new cases have since been filed. We now only have 26 caveat cases outstanding. Once again, I express my sincere gratitude to Justice Matthew for his assistance over the last few months. I would like also to express thanks to Justice Cumberbatch, whose sojourn in Dominica was all too short. He willingly stepped in to fill the void when our own Justice Baptist took up an appointment as Acting Justice of Appeal. We appreciated the work that he did while he was here, and we are grateful to him. I wish to offer congratulations to Justice Baptist on his continued appointment as an Acting Justice of Appeal of the Eastern Caribbean Supreme Court. As Dominicans, we are very proud when our citizens attain high office. We have every confidence in the ability of Justice of Appeal Baptist. We are sure that he will approach this new task with the same quiet but forthright manner that he displayed as a High Court judge, and we look forward to many well-reasoned judgments from him as he continues to ascend the judicial ladder. Justice of Appeal Baptist is being replaced by Justice Brian Cottle. This is by no means Justice Cottle's first encounter with Dominica, having served here during his tenure as master, albeit on short-term visits. Justice Cottle, I know that you were officially welcomed by the Honorable Minister most warmly last night, but I wish also to personally extend my words of welcome to you. Having worked here before, my Lord, you know what to expect from the bar. I am sure that you will have the bar's full cooperation. As you will notice as you look around, the bar is a very young bar, and as such we will look to you for guidance. The Minister of Legal Affairs has pledged his full support in making sure that your stay here is a pleasant one, and you can be assured that all efforts will be made to ensure that this is done. I wish at this point to return to where I began, and that is with the backlog of cases in the court, caused in the main by having only one resident judge. The Honorable Prime Minister, being sensitive to the needs of the justice system and recognizing the limitations under which it was operating and the importance of having an efficient court system, made a request of the Chief Justice for a second judge to be assigned to Dominica. The Chief Justice responded to that call, and as of the 25th of October, Justice Bernie Stevenson Brooks will be taking up residence in Dominica as the second resident judge. This has been long awaited and will make a significant difference in the speed with which matters are dealt with in the courts. I would like to sound a note of caution to our lawyers. Things as we know it are going to have to change. There will be 2 high courts in operation and matters being heard more quickly. The time perhaps has come for you to consider going into partnership with others. This may well herald the disappearance of sole practitioners. I do not think that the courts will tolerate for very long request for adjournments because you have a matter in the other High Court, you will need to organize yourselves appropriately. One of the complaints and deficiencies that have been identified in administering justice is the length of time that indictable matters take to be heard in the High Court, having first to go through a preliminary hearing in the Magistrates' Court because of the backlog there. As the Chief Justice has said, the criminal division of the court is designed to reduce the length of time for these matters to be heard. Rather than have witnesses attend court 9-10 times while they wait to give evidence before the magistrate, these matters will be dealt with primarily on documentary evidence, and the witness may only need to attend once before a judge when a sufficiency hearing is conducted to determine whether there is a case to be tried in the High Court. Having a second judge in Dominica has enabled us to begin looking at implementing the criminal division of the court in Dominica. We met with the Deputy Court Administrator of the Supreme Court yesterday, and we have put a plan in place to see how best this can be approached, with a view to having the criminal division of the court established next year. This will result in a quicker disposal of matters, less time being spent on remand, a reduction in the workload of the Magistrates' Court, and therefore increased efficiency, and we look forward to its implementation. This is indeed exciting times to be part of this process when the court is evolving and expanding. The Chief Justice in his address this morning spoke to the need for the professionalization of the bar. The urgent need to have a Legal Profession Act implemented effectively in all the jurisdictions of this court cannot be denied. An effective system must be put in place to ensure that lawyers are properly regulated like any other profession, and that those who fail to abide by the ethics and obligations of the profession are dealt with quickly, efficiently, and effectively, so that persons who are wronged get swift redress. While most lawyers act in a professional manner towards their clients, they all get tarred with the same brush by the few unscrupulous ones who take advantage of others. I was heartened to hear the President of the Bar state last week that the Dominica Bar wants to have the Legal Profession Act passed. I know that a comprehensive review was done by the Bar of the draft bills using the OECS model as a template. We have been awaiting for some time now the detailed comments of the Bar on the bill so that it can be finalized for presentation to Parliament. Mr. Bruni will have heard the expressions of the urgent need for regulation and discipline. Therefore, I wish to inform him that we cannot wait much longer. I urge him to have the comments of the Bar forwarded to the Aegis Chambers before the end of the year, as it is my intention, barring unforeseen circumstances, to have the Legal Profession Bill brought to Parliament for enactment early in the new year. Lords, I do not know where we have lost our way, but I think that somehow we have. The traditions and practices of our profession seem to be withering away, and if we are not careful, they will be lost. The protocols and deference that in the past we have shown to our judges and senior members of the bar, the respect for our colleagues, even those who are on opposing sides, is being eroded. The attacks that we lawyers launch on the integrity of our justice system for personal or political gain is very real and is a cause of great concern to me. When a member of the legal profession can make a statement on the radio to the effect that a senior member of the bar is winning his cases only because he is friends with the judges, but he cannot win cases at the Privy Council because they are not his friends, what are we saying? What kind of message are we sending to the public? When we impugn the integrity of our judges and our court system without justification, and when we ought to know better, how can this be allowed? Given the important role that we play in society, it is imperative that we hold ourselves to higher standards. That there is need to have a Legal Profession Act enacted, I believe there is equally a need for judges, and I use this term in this context to include magistrates, to critically review the way in which they handle the behavior of others in their courtroom.